When an estranged sister-in-law comes back and tries to claim the payable on death account you received from your brother, what do you do? I'm Valerie Zammitti of Zammitti Law. We're an estate planning practice in New York and New Jersey. If you have any questions in the estate planning or probate and administration areas, we can help you and provide free consultations. You can reach us at yourplanningattorney.com. We, every day, provide peace of mind to families through our high client value services. And speaking of value, we are also here to educate everyone. So please ask questions and don't forget to share so together we can help some folks along the way. So this is a pretty frustrating and a little bit of an invasive situation the way I hear it, in that this estranged sister-in-law has come back after the passing of her husband, and the decedent's brother had received an account via payable on death, and now she's kind of being forceful and obtaining information from the bank and all these sorts of things. So here's my 2 cents on it. First off, and these are based on the laws that I know in New York and New Jersey. When you are still married, so for all of you folks out there who are separated from your spouse still has rights to your estate at your passing. And it doesn't matter that you've necessarily been separated for a long period of time. It could be 20, 30 years. The state law will determine if you are still deemed a spouse. And in circumstances, especially here in New York and New Jersey, the answer is yes, unless you are fully divorced or you meet certain state thresholds that determines that you are a disqualified spouse, or that person would be a disqualified spouse. That could be so much as saying you have to prove that they abandoned you, right? And in different circumstances. And that's not always easy or possible. So if you can't reach that level of proof to say they're a disqualified spouse, and remember, it's not you showing it, it's your family members, after you're gone, then that spouse could have a right to claim what's called a spousal elective share. Now, what does that mean? Well, if the estate plan or the assets that remained went to other people and the spouse received nothing, even though they had rights as a spouse, they can file a claim in the court for that elective share. And in our neck of the woods here, commonly it's the greater of $50,000 or 1/3 of what they call the decedent's net estate. I'm going to talk about that very briefly, but I don't want to get too detailed into the technicalities. The net estate is not necessarily what just goes through the probate court. So like a payable on death account that does avoid probate because there's technically a beneficiary listed, right? At the death of the person, that's who it goes to. But when there is a spouse who files an elective share, the net estate starts with what's called the augmented estate. And that includes not just the things going through probate, but other assets that were in the control of the decedent, okay, before they passed. And a payable on death account is such an account that they had access to. It was their account, even though it was slated to go to someone else after their passing. And so that asset, like a payable on death account, could be construed as a portion of that net estate, even though it didn't go through probate. Of course, any things that did go to the spouse comes off of the value that they could receive. You have to look at state law. The calculations can vary, and they can be quite detailed and include certain things and exclude other things. So it has to be, you have to go through it line by line, looking at the inventory of assets for that decedent. Now, that all being said, right, the banks or any financial institutions really shouldn't be sharing information directly with someone who's not an owner and not a beneficiary, right? We don't handle banking law matters, but I'm certain you can file direct complaints with the bank or the regulatory bodies for financial institutions, because that's not right. Further, you do need to, you do not need to engage directly with the estranged sister-in-law. Like, that doesn't make any sense. Why create more complexity and strain for everybody? It should really be handled through the separate counsel and the court. Again, we don't litigate, but it's important that you have parties involved to assist. Now, certainly, if someone is failing to use common sense and not leaving you alone when asked, then there are steps you can take to file complaints, get restraining orders, and things like that if necessary. But it's always a good idea. Keep your records as to what's happening when, and go through the proper channels if you have to take it that far. Usually these things, quite frankly, will settle out. Once you have the facts in place, you can talk about numbers and just try to resolve it as quickly as you can. That's my suggestion. But no, most states do have, or I can't say most states, the states I live in or practice in have this potential of disqualifying the spouse based on state law. So you have to look at that first. I hope that's helpful. I hope you've learned something new. And again, I'm Valerie Zammitti of Zammitti Law. We're an estate planning practice in New York and New Jersey, and we provide peace of mind to families through our high client value services. If you do need help with estate planning or the administrative process after someone's passing, we can help, and you can reach us at yourplanningattorney.com. Please don't forget, share, and always take care. Bye-bye.